Okay, welcome everyone. Good afternoon. Thank you for joining us for our lunchtime webinar, Disability Accommodations for Students of All Ages, Breaking Down Stereotypes and Barriers Through Advocacy. I'd like to welcome Mary J. Goodwin-Oquendo, practicing attorney for Joanne Simon PC. She is also an alumna of the class of 2006. And she's going to share so much information with you today. We are so blessed to have her with us. And Mary, I just want to thank you so much for being here. And before we get started, before Mary tells you a little bit about herself and what she will be discussing today and also answering your questions, we just want to let you know that we do have a chat box feature that if you have any questions or if you're having any trouble hearing us or seeing us, please feel free to let us know in that chat box. You can also raise your hand if you have a question at any point by clicking the little hand icon that you might see on your screen. We also recommend that you dial in using your phone audio. Phone audio tends to be a little better for webinars as opposed to the computer audio, but of course you have the choice to do either. We also want to let you know that Mary will be covering a lot of information in this webinar, so if you have a question, you might want to hold on to it, but if you might have to run and you want to make sure that your question is answered, your webinar will be recorded, so we want to make sure that your questions will be answered and you will be able to view the webinar at a later date. So with that being said, I'd like to introduce Mary J. Goodwin-Oquendo.
Thank you so much. Thank you so much, Taryn. Again, I'd like to thank you and St. Joseph's for extending me this opportunity to deliver today's webinar. I hope that everyone will walk away with a lot of useful information and practical tips that they can utilize in their personal lives or share with those around them. So a bit about my background. As Taryn said, I am an alum of St. Joseph's College, Brooklyn, born and raised. I received my Juris Doctor from Syracuse University. I attended immediately after leaving St. Joseph's. One thing that's interesting about my background is that there are a lot of reasons why I chose to pursue a career in disability civil rights. First and foremost, growing up, my younger brother was diagnosed with a number of learning disabilities, and he was also labeled as being on the autism spectrum. Now, this was in the late 80s, early 90s, before much was known. There was a lot of ignorance. There were a lot of experimentations with regard to what kind of placements and services worked. And I distinctly remember, even as a child, the importance of advocacy. But for my mother's advocacy, my brother would not have had an opportunity to be placed in the first inclusion classes in New York City. But for my mother's advocacy, people who didn't really know him would have placed barriers in the way of his success, and they would have limited what he could have achieved. Now, when he was very young, they said, oh, well, he'll never talk, he's probably going to have to be in an isolated classroom. He'll never graduate high school. And he did all of these things, and he was brilliant. It's just that he was very different in how he could express his knowledge, how he could demonstrate his abilities. I saw so many kids get left behind in my brother's classes whose parents, for whatever reason, whether it's due to lack of knowledge or lack of time because they were working or had other obligations, they couldn't advocate the same way that my mother did, so their kids were left behind. And I knew then the importance of advocacy. Later on, myself, in St. Joseph's College, I was diagnosed with fibromyalgia. That is a neuromuscular condition that involves the misfiring of your neurotransmitters, a lot of musculoskeletal fatigue, also cognitive fatigue and brain fog during flares, a lot of exhaustion. I was young. I was in my late teens, early 20s. I didn't really know how to manage that. But because St. Joseph's was a very nurturing and small school, I was able to receive a lot of support that other students going through similar circumstances may not have been able to receive through their schools. So if I needed additional time to complete a paper, I would go to my professors, explain the situation. They would informally allow me time extensions. If I had any other issues. I felt comfortable going to my professors and communicating my needs, and they worked with me. Now moving on to law school, it was a new environment. You know, there was so much that I had to adjust to, the rigor, you know, a lot of stamina was required, and here I am with a condition that causes chronic fatigue and pain, and I didn't really know how to cope. And that is where I learned about formal accommodations. So went to the school student life office. They told me what accommodations were, what the process was. I spoke to one of my disability law professors, Professor Arlene Cancer, and she told me what my rights were, you know, gave me ideas about what accommodations would be appropriate. So I went to my doctor, submitted documentation, and then for law school and for the bar exam, I received accommodations, which allowed me to demonstrate my abilities so that I wasn't hindered by my pain and my fatigue. So I'm coming to you as someone who has family members with disabilities. As I said, my brother has learning disabilities, and also he's on the spectrum. My mother has a physical disability. She has she has rheumatoid arthritis, and I myself have fibromyalgia. So many of you, perhaps when I'm sharing this description, you're thinking of people in your life, you're thinking of yourself, your own circumstances, and it's triggering things. So, you know, as I will explain in a moment, anyone who's listening to this can benefit from this program. If you are a K through 12 student, you'll benefit. If you are the parent of a K through 12 student, if you're a college student or a college professor, even an administrator, if you are a psychologist, a therapist, a medical doctor, you will walk away from today's program knowing more about what conditions constitute disabilities, what are appropriate accommodations for those types of impairments, and how to go about maneuvering the system. Okay, so the first question that you're probably asking yourself is, okay, I have a difference, but is that a disability? So for the purposes of our program, when I'm talking about disabilities, I'm talking about disabilities as defined by the Americans with Disabilities Act and Section 504 of the Rehabilitation Act. Many of you may be familiar with the IDEIA, but that only applies to K through 12 public schools, and the ADA and Section 504 are considered broader. They offer more protections than the IDEIA. So that's what we'll be focusing on later on. If you'd like to learn more about the IDEIA, I have a few links. But going back to our operative laws, a disability is defined as a substantial limitation in a major life activity. What's a major life activity? Major life activities include things such as reading, writing, learning, concentrating, communicating, sleeping, sitting, standing, test taking, and working. This is a non-exhaustive list, but these are some of the most common major life activities that, if impaired, will necessitate accommodations in a higher education setting. So on this slide, I have identified some of the more common physical, cognitive, and psychiatric disabilities. For physical disabilities, first thing that a lot of people think of are those that are visible. So if you see someone with a cane or a wheelchair, people see that right away. Oh, well, that's a disability, right? So that's your reduced mobility impairments such as arthritis, cerebral palsy, but there are many, many other physical impairments that are invisible as well. So that includes deafness, blindness, and vision impairment. It's very important to note that you don't have to be 100% blind or visually impaired in order to be disabled by your vision condition. Crohn's disease, or IBS, multiple sclerosis, diabetes, fibromyalgia, chronic fatigue syndrome, sleep disorders, allergies, sciatica, carpal tunnel syndrome, and preeclampsia. I'd also like to note that for the physical conditions and also the cognitive and psychiatric conditions that I'll go into in a moment, these don't have to be permanent in order to be disabling. Most of these conditions might be chronic or episodic, but oftentimes others are really severe, even if they're considered temporary. So for example, let's take preeclampsia, sciatica, carpal tunnel syndrome. Those are some of the more common physical impairments that could be caused by a pregnancy, for example. Pregnancy itself is not a disability, but conditions that are caused by pregnancy can be disabilities. Now, moving on to cognitive impairments, reading disorder, writing disorder, dyscalculia, nonverbal learning disorder. I could keep going on about, there's so many different kinds of learning disorders that exist in the diagnostic manuals. Also, attention deficit disorder and autism. And lastly, for psychiatric disabilities, we have anxiety, depression, bipolar disorder, post-traumatic stress disorder, which I must note, a lot of people think of it as only within the PTSD only exists, for someone who, let's say, has served in our nation's armed forces. That is not true. Very often, survivors of sexual assault or other abuse they have PTSD, and also individuals who live in very violent neighborhoods can have PTSD as well. And obsessive compulsive disorder, and anorexia and bulimia. Again, this is a non-exhaustive list, but these are some of the most common psychiatric, cognitive, and physical impairments that are disabling. So there are a lot of myths that will be debunked during today's program. As you can see from the prior list, only physical disabilities count. Not true at all. Only learning disabilities count. Not true. You can't have a disability if you're smart. That's the case whether you have a physical disability or even if you have a learning disability. Very often people will say, well, I didn't know that this person had a learning disability, or I don't believe that they have a learning disability because they're bright. The two are not mutually exclusive. You can't have a disability if you've been successful is another myth. That's untrue. I mean, I'm an example of that. I was diagnosed with a disability when I was in college. And I came to college on an academic scholarship. I was valedictorian when I graduated. I went on to law school. There are many doctors and lawyers and teachers, any profession that you can think of, where individuals have disabilities and they found ways to either self-accommodate, utilizing strategies to mitigate the effects of their undiagnosed disabilities or diagnosed disabilities, or they've received formal accommodations. Another myth that I believe is very, very important, and I cannot stress it enough, is the idea that granting accommodations to someone with a disability gives them an unfair advantage. That's not true. Accommodations don't exist to provide an equal outcome. What they do is they exist to provide an equal opportunity to have an accurate outcome. So the accommodations that I will describe later on in this program help individuals with disabilities to compete on a level playing field. It helps them to accurately demonstrate their knowledge and their abilities, and it also helps them to make sure that whatever the metric is, whether it's a test or an assignment or a course, that is measuring their abilities or the tested subject matter and not the impacts, the substantial limitations of their impairments. So who is required to accommodate disabilities? Public K through 12 schools. As I said previously, public K through 12 schools are subject to the IDEIA, but they're also subject to Section 504. So sometimes you may hear of students receiving IEPs, but then also 504 plans. Also, private K through 12 schools that receive federal financial assistance. So if you have a school that's exclusively private, they accept no federal money. Unfortunately, it is very unlikely that they will be required to abide by the Americans with Disabilities Act or Section 504. But if the school receives grants or other federal financial assistance, then they have to abide by these disability laws. Public undergraduate and graduate professional schools, obviously, because they're public, they're subject to these federal laws. And private undergraduate and graduate professional schools that receive federal financial assistance are likewise required. Additionally, one thing that I mentioned that I left out in one of the prior slides is that you don't just have federal laws protecting the rights of individuals with disabilities, you also have state laws. So for New York State, for example, that would be the New York State Human Rights Law and the New York City Human Rights Law. For the purposes of understanding obligations, those state and city laws cover the same entities as the ADA. So if someone is required to accommodate you under the ADA or 504, they will be required to accommodate you under your state and your city human rights law as well. Now, with regard to entities and organizations that offer standardized exams that need to accommodate you, that includes all of them because they're all public. They're all extending themselves to the public. They're offering a service, and they're considered under the law a, quote, public accommodation, close quote. So the College Board, who administers the the AP, SAT, and SAT subject tests, they are required to accommodate you. Same thing with the ACT. The AAMC administers the Medical College admissions test, which is known as the MCAT. They are required to cover you. Same thing for the law school sister organization, the Law School Admissions Council. Various state bar examiners, the national medical boards, and the national specialty boards. All of these tests are required to accommodate you. Same thing for teacher licensing exams. Okay, so once you realize that you have a physical, cognitive, or psychiatric impairment and that you are unable to compete on a level playing field and you need accommodations and you are interacting with an organization or an entity that is required to accommodate you, the next question is, well, what kinds of accommodations are available? So I will just walk you through some of the more common accommodations. Keep in mind as we're going through this that this is a non-exhaustive list, and accommodations are to be granted on an individualized basis. So what works for one person with one disability may not necessarily work for another person with another disability. So extended test time is one of the more common accommodations, and the common increments of extended time are 25% extended time, which is usually referred to as time and a quarter, 50% extended time, which is referred to as time and a half, 100% extended time, which is referred to double time, and then I've seen triple time, which is 200% extended time. That has been granted before, but it is very rare. I would definitely have to say that of the 4 increments that I've just described, time and a half is the most common. Additional accommodations include off-the-clock breaks. So sometimes individuals may need to pause, whether to refocus themselves, whether to walk around, to alleviate pain or discomfort, whether to check their insulin. There are a number of reasons why someone would need off-the-clock breaks. Also, testing over multiple days is another accommodation. When someone needs additional time to read, to write, to comprehend, it's fatiguing. So if they're working 50% longer than everyone else, or twice as much, or however, oftentimes there aren't enough hours in the day, literally, to administer those accommodations. Plus, the individual will likely suffer cognitive and or physical fatigue that would impede their performance if they're not granted additional testing days. A computer for essays or a computer for multiple choice exams is another accommodation. Alternative format and assistive technology. Now, when most people think of that, they're thinking of, okay, well, you have someone with a vision impairment who can't see a computer screen, so they'll utilize software that will allow them to have what's on the screen read to them by the computer, and they'll be able to speak what they'd like typed to the computer, and it'll be transmitted that way. That's a common situation, but it's also common for individuals with various learning disabilities, particularly those with dyslexia, to utilize assistive technology in this way. Additionally, a human reader is a good accommodation. Sometimes, depending on the person, perhaps a human reader is better for them than assistive technology. Oftentimes you'll have testing entities try to substitute one for the other arbitrarily, but that's inappropriate. You should really go by what works for the individual. Same thing with the scribe, a calculator, enlarged textbook font. And again, this is another accommodation that isn't just helpful for individuals with vision impairments, it's also helpful for those with dyslexia, because individuals with dyslexia see words differently than everyone else. That's why it's difficult for them to read. An enlarged Scantron sheet, the bubble sheets. If someone has difficulty with visual tracking, or they have difficulty aligning things or focusing, just think of how cumbersome filling out a Scantron sheet could be, especially for a long test where there are dozens of questions, hundreds of questions. Without that accommodation, or without an alternative way to record their answers, the test would not be measuring their knowledge or even their responses. It would just be reflecting the effects of their disabilities. Lastly, access to food and drink. That's helpful for a number of impairments, not just those that are physical, like diabetes. Oftentimes, individuals with attention deficits or anxiety, they too will benefit from having access to food and drink because it helps them to re-energize. Remember, living life with any of the impairments that I've described can be very tiring and very fatiguing, so these things help to level the playing field. Okay, so how do you start the accommodations process? You know that you have a disability, you know that you have a covered entity, you have some idea perhaps of what accommodations you need. What do you do? Next, I will walk you through how to secure medical documentation, how to secure academic documentation, and then how to secure other documentation from other parties that will help to shed light on your individual limitations. Okay, so for medical documentation, under the law, this has to come from a qualified professional. A qualified professional isn't just a medical doctor. It can be a psychologist. It can be a therapist, speech therapist, occupational therapist, physical therapist, learning specialist. Anyone who is a professional would be qualified to submit this kind of documentation. It's very important for them, however, to state their professional experience and qualifications. That helps to establish that they have the knowledge and the fund of experience to recommend accommodations for you. So are they licensed by any boards? Are they licensed by any states? How many years have they been practicing? What are their areas of expertise or specialty? All of that should be included in the documentation. Now, this documentation doesn't have to be an extensive report. For psychologists, it more so is, but for everyone else, a letter is sufficient under the law. They should also state a clear diagnosis. Diagnoses are made pursuant to the DSM, which is the Diagnostic and Statistical Manual of Mental Disorders, or the ICD, the International Classification of Diseases. So often in practice, I have seen individuals with long histories of disabilities get a big no from schools or testing companies because even though they have a long paper trail and lots of documentation, no one made a formal diagnosis. Under the law, that shouldn't matter. And after pushback, that's usually something that we're able to overcome, but you should avoid it anyway. Make sure that a diagnosis is made, a clear diagnosis. The documentation should also discuss inter and intra-individual differences. So how does the individual with the impairment function compared to most people? And also within their own profile, their cognitive profile, their social profile, etc., what discrepancies exist. So for example, if you have someone who's incredibly intelligent, their reasoning level is very high, they're able to perform exceptionally well compared to most people, but they need more time than most people to do so. That's an example of a difference that should be highlighted. Also, the clinician should discuss his or her familiarity with the academic environment or the specific exam that is posing a difficulty for the patient. This helps to demonstrate that the recommendation isn't something that's being pulled out of thin air. This helps to demonstrate that the clinician, the qualified professional, is making an individualized assessment and an individualized recommendation. And that just goes back to establishing that they are qualified to make this kind of determination and or recommendation. The documentation should also contain a very clear history. We need a narrative. We need to know how this person has been able to get from point A to point B. Have they received any informal accommodations? Have they received any formal accommodations? Have they encountered any difficulties in their personal, academic, or social lives because of these impairments? It's very important to really go into great detail to the extent that you can. This is especially important for the medical doctors and the psychologists, but I would say that all of the qualified professionals should delve into that. Lastly, it's not sufficient for the documentation to just say, this person should be accommodated. Accommodated with what? So, that long list of example accommodations that I just went over, the qualified professional should specify what they believe would assist this individual, and they should also keep in mind that the individual knows best what works for him or her. So let's say, the doctor says, well, this person would benefit from extended time and breaks. But the person says, well, instead of having breaks, I feel that I really need just additional extended time because of how I process information. That's something that should be taken into consideration by the doctor. Now, there are also a few things to note before we move on to the next slide. Firstly, under the law, clinicians are not required to submit the results of every test that they administer. Some tests, for whatever reason, may be invalid. There may be something weird about the administration that just doesn't make sense, that is inconsistent with the sum total of the patient's experiences and all of the other objective and subjective data that's available. In that case, the clinician does not have to provide data that they feel would be misinterpreted, or provide score printouts, or detailed stats that they feel would be misinterpreted. And lastly, for the K through 12 students who receive accommodations under the IDEIA through an IEP, you should note that the evaluations, usually they're psychological or psychoeducational speech evaluations. Unfortunately, they are usually insufficient for standardized testing companies and colleges because they're very brief. So you should make sure that it's on your radar that if you need accommodations on a standardized exam or for college, post-grad, it may be necessary for you to, or for your loved one or your student, whoever it is that needs this information, to undergo a supplemental assessment that's more detailed. Okay, the next important piece of documentation is information from educators. Now, especially for the younger grades, teachers spend more time with students than their own parents in many situations. So they have a unique opportunity to observe difficulties or limitations that may not necessarily be apparent when the student is home, working free of strict time constraints, working within a different environment where there are no distractions, or where they're free to utilize strategies that can't be utilized in school. Documentations from teachers for this reason are very, very important. So not only should the documentation from the teacher or the professor discuss school culture and environment, it should discuss the grading rubric. The grading rubric is very, very important for these things because it will help to explain why someone has or has not been able to compete on a level playing field. For example, let's say you have a class and the tests are administered for the full period, a full 60-minute period, but most people are able to complete the test within 30 minutes. A student who needs the full 60 minutes to complete the test is requiring significantly more time than his or her peers to demonstrate their knowledge and complete the test, but they are not requiring extended time accommodations because there's more than enough time for them to complete the test anyway. Another example, let's say that the assessment is essay-based as opposed to reading-based. If someone has dyslexia, for example, if there's a reading test, that limitation will very often be illuminated. However, with an essay test, they're not having to read. They're pulling from their mind, putting on the page, so they're able to demonstrate their knowledge without being impeded by their slow reading. So these are just a few examples. Documentations from teachers should also include, like I said, behavioral observations during and after class, during exams. Is the student anxious? Do they need to ask a lot of questions? Do they meet with you after school or after class to reinforce their understanding of material? And I don't just mean every once in a while, I mean consistently. Also, compare the student to other individuals without disabilities. So as I said, are they the last person to finish? Are they nervous? Are they anxious? Do you notice a disconnect between their homework assignments and their performance on tests? All of this is very relevant. And lastly, informal accommodations. So let's say, going back to the testing example, 60-minute period, but everyone in the class needs the full 60 minutes to complete the test, but the individual with the disability needs more than that. You let them stay after class to finish up, or you let them come back during a different period to finish up. That's an informal accommodation. Also, if a student needs additional time to complete a paper or an assignment, which was often the case with me at St. Joseph's because of my fibromyalgia flaring up, if you're granting them that extension, that is also an informal accommodation. So you, as educators, you really have to perform a forensic analysis of sorts and think, how is this person functioning in my class? How am I accommodating them? Did I miss anything? And sometimes teachers miss things, and it's not for negligence reasons. Sometimes classes are oversized or under-resourced, or the person is really quiet, so you don't have an opportunity to pick up on things. All of this is information that should be included in a letter or attestation from a teacher or professor. Okay, next, statements from your support system. Your support system can include anyone from your parents to your siblings, spouses, your husband, wife, whoever, other family members, tutors, non-medical therapists, peers, pretty much anyone who has an opportunity to provide additional information on how the individual with the disability is able to meet demands or unable to meet demands. That information, those accounts are helpful. So let's say a parent, they can attest to their child working long hours at home, having to sacrifice social engagements and extracurricular activities to keep up with studying. Or, a parent, a spouse, a friend can attest to someone being anxious or depressed or needing assistance. They're spending so much time keeping up with school that they can't perform chores, or they can't pay their bills on time. They can't keep a schedule. They need organizational support. All of that information is very helpful. Now, once you have your supporting documentation, how you request formal accommodations will depend on the institution. So, as I said, for K through 12 public schools, the IDEIA applies for that, but also Section 504. But since it's primarily IDEIA, I won't really go into that. But here I've included some links for individuals who would like to have information on that. So there's a link to the New York City Department of Education outlining the IDEIA, outlining the IEP process, and also Section 504. I've also included a link to an organization called Advocates for Children, and they provide assistance for parents who need help navigating the process, whether it's because they don't know where to start or they've hit a roadblock. The same goes for the Council of Parent Attorneys and Advocates, also known as COPA. Their link is there as well. Now, for private K through 12 schools, we pretty much have a different process for every school. There's no uniformity there. Usually, you'll be able to reach out to the school's learning specialist if they have one. If they don't, reach out to a dean, and they have to find a way to accommodate you. But again, this is only if it's a private school that is subject to the ADA, subject to 504, subject to the New York City human rights laws, or the local laws of whatever jurisdiction you're in. With regard to private and public colleges, law schools, medical schools, the colleges, universities have it much more together. If you go, well, generally speaking, I have seen a few things in practice. If you go to the school's website, very often they will have a disability section. If they don't have a disability section, they have a student life section. If you need accommodations, Be careful about who you disclose that information to. Don't make the mistake that a lot of students do. I did it. I was fortunate that it didn't backfire on me. That was before I knew better. But make sure that you're not disclosing your disabilities to your professors, you know, all willy-nilly, for lack of for a better term. That's because very often people will talk, they'll make suggestions or comments that are not helpful, that are biased, and now you self-disclose your disabilities, and you could unfortunately be subject to discrimination before you've had an opportunity to secure accommodations. Additionally, as I said, the Disability Services Office, Student Life, if you have questions about how to secure accommodations from a college and you don't know where to go, you don't feel comfortable reaching out to anyone, you can contact our office. You can also contact the U.S. Department of Education for guidance on that. Next, standardized exams. All of the standardized examiners are required to accommodate your disabilities. So I've included the direct links here for the College Board, the ACT, the MCAT, the LSAT, the GRE, the GMAT. I'd also like to just go back to private and public colleges. I realized that I left something out. A very important resource, AHEAD, the Association on Higher Education and Disability, is a wonderful resource, not just for individuals with disabilities, but especially for schools. The organization is primarily made up of school administrators and deans and professors. So, if you have a school that's willing to help you, but they're ignorant as to what accommodations are and what the process is, I would definitely point them to AHEAD. So I've touched on a few of these things, but when you're navigating the accommodations process, there are a few things that you absolutely need to be aware of. Confidentiality and bias. You don't have to disclose your disabilities to anyone, but if you need accommodations, you have to, because schools and testing companies can't be mind readers. You can't be, struggling with these conditions and then you fail out, and then hold the school accountable or hold whoever accountable when you never made it known that you had a disability. With regard to expenses, as I said, it may often be necessary to undergo supplemental psychoeducational or psychological evaluations. You may also need to go back and forth with your doctor to undergo additional tests and have them produce documentation. It can all become very costly. So that's something to keep in mind. And also deadlines and timeliness. All of the entities that I've discussed, so the schools, the testing companies, the licensing boards, and they all have different guidelines for processing accommodations. Some of them make terminations in as little as 2 weeks within submitting documentation. Others take months. So you really need to plan ahead. Okay, so now what should you do if you are discriminated against on the basis of your disability? Discrimination includes the refusal to accommodate a documented disability. And when I say accommodate, I don't mean that, they just throw the individual with a disability any kind of accommodation and like that's sufficient. To truly accommodate is to provide those modifications that level the playing field. So a school or a testing company is discriminating if the individual needs 50% extended time, they're only granting them 25% extended time. If the individual with a disability needs assistive technology, doesn't know how to utilize a scribe or a reader, a human reader, or a human scribe, and the entity is like, okay, well, that's all we're going to give you. They've granted something, but it's not accommodating that person's disability, so it's still discrimination. Discrimination also includes harassment. So often, I've seen people push out of programs, particularly medical school programs. I've seen that, and sometimes in law school, when they disclose that they've had a disability. There's bullying that takes place, not just through peers or from peers, but also from the administration. It's terrible, but it happens sometimes. Also, dismissal from the school. So if you requested accommodations and they've ignored you or denied you, and then you're dismissed for failure to maintain a particular GPA or meet a requirement, that's also discrimination. Now, when you realize that you're being discriminated against or that you have been discriminated against, you really need to act fast. And that's because, one, you'd like to mitigate the damage that can be done to you academically and financially. And also, there are different clocks that are running, different statutes of limitation. So, for example, I list different ways to handle discrimination. If you are in a school and you're being discriminated against, I recommend filing a complaint with the U.S. Department of Education's Office for Civil Rights. They have a clock, I believe it's 180 days. You have to submit your complaint within 180 days from the discriminatory act. So if something happened like 2 years ago and you just let it go, unfortunately, it's very unlikely that you would be able to complain about that. Also, if you complain timely, while you're still in the midst of this situation, they have a process called rapid resolution, early complaint resolution. I've heard it referred to those two different ways, where they will have you and the school, if both parties agree, meet with an impartial OCR mediator, and they'll try to help everyone reach a resolution. So this is a way for a student to get assistance free because it's a federal agency and it's rather timely. Now, if you're dealing with a testing company, unfortunately, the best way to get a timely resolution for that would be to either appeal yourself or to retain an attorney, such as myself and Joanne Simon, to appeal on your behalf. That's because the agency that is charged with enforcing the ADA for testing companies, the Department of Justice the Department of Justice Disability Rights Section, they are they have a lot on their plate. There's a lot of discrimination nationally, and it can take months or years to reach a resolution through that. So I'm not saying don't file a complaint with them, but don't expect that you will receive a rapid resolution. You can also contact your local protection and advocacy organization. Each state has one, so I've included a link there for our local protection and advocacy agency. You can file a complaint with the administrative agencies that enforce the New York State and New York City human rights laws. In my experience, their process is not as streamlined as, let's say, the DOE, and you are probably less likely to receive rapid resolution through those means. And lastly, you can sue. Suing is expensive. There are no guarantees, but very often it is a tool to get the accommodations that you need. Sometimes cases settle quickly, sometimes they go on for years. It really is very fact specific. So if that's something that you want to pursue, you and your attorney and your qualified professionals would really need to have a very open and honest discussion about that. So that is all for my presentation. Now we open the floor to questions.
Mary, thank you so much for that. The information that you gave in this presentation, I hope people were taking screenshots of the slides. If not, we'll definitely be sending them to you. But Mary, I just want to thank you for the thoroughness and the context that you provided for us, all of the different lenses that you put on this particular topic. It's amazingly valuable. And one of the questions that we wanted to start with is, how does animal support come into this? There are people that we've seen maybe in different environments that have animals as emotional support or some kind of support. How does that fit into disabilities?
Yes, so there are two types of support animals. One is a support animal that performs tasks for an individual with a disability. So that animal will, let's say, grab things, or they'll help the individual cross, or they'll notice when they're sick or they're about to have a seizure. Those are the more common kinds of service animals. Pardon me, those are service animals under the law. What people are seeing more commonly are emotional support animals. So again, that's service animal versus emotional support animals. An emotional support animal would apply for someone that, let's say, has anxiety or depression or PTSD, and that animal helps to calm them so that they're able to participate in the daily aspects of living in society. Under the law, service animals are afforded greater protection, right? So it's difficult for a restaurant or an airline or a school in many cases to say no to a service animal. But then there are other considerations that you have to have. What if you have someone who is at the school? And I'm going to use a school for an example because these other encounters are, in passing, right? There's no consistency there. But let's say you have two students in a class and one needs a support animal and the other one has a phobia of dogs, or they have severe allergies. Both of these students need to be accommodated, so something would need to be worked out. With regard to emotional support animals, that's still a growing area of the law, and it's very case specific. There really is a burden that needs to be overcome by the applicant and their clinician in establishing the necessity of the support animal.
Thank you, Mary. Another question, when you mentioned about disclosing, and you mentioned being very careful about who you disclose a disability or a situation to, can you say a little bit more about that in terms of how you know who you can disclose to and who might not be the best person?
Yeah, so that's an excellent question. So I am going to focus on post-secondary education, so colleges, grad schools, professional schools. You kind of have to walk a line with disclosure for these institutions. If you are an individual with a disability and you know that you have a disability before you go to these schools, you want to the best of your ability, make sure that you're choosing a school that is knowledgeable about accommodations and not known for discrimination and willing to assist you. But also, you don't necessarily want to disclose your disabilities before you're admitted. So I would say, in that regard, to protect yourself, don't disclose your disabilities in your initial application unless you want to. And after you're admitted, immediately gather your documentation, disclose your disability before classes so that you and the school have enough time to work out what the accommodations are. Now, accommodations can be requested at any time. You're not limited to just the beginning of the semester, but the sooner the better. With regard to who you choose to disclose to, once you choose to disclose, if you disclose to a professor, they don't necessarily have the same confidentiality obligations as, let's say, a dean or a counselor at the school or an office that deals specifically with disability matters. I've seen very often that sometimes students will disclose to professors, and then the professors will mention it to someone else, and it's like a game of telephone. So not everybody knows that the student has a disability, and that's not productive for anyone. If the student discloses to disability services or the office for student life, that information should stay there, and then that student would be able to get the accommodations that they need without anyone knowing what their specific disabilities are. Because let's be honest, some disabilities are still stigmatized in society more than others, and bias is very real.
Absolutely.
I hope that answers the question.
Yes, thank you. Mary, we actually we have a question from one of our attendees right now live. Her name is Melanie. She says, good afternoon, Ms. Oquendo and Ms. Katusian. Good afternoon to you as well. For those students who are disabled physically, mentally, or otherwise, do the respected school institutions have a specific or assigned advocate to act as an intermediary to help them navigate the process of getting disability services applied to their specific situation?
The answer to that is not necessarily. So you don't have an advocate in the school to advocate on your behalf, but especially for post-secondary schools, if you feel that you've been subject to discrimination, schools should have a compliance officer that you can go to file a grievance. And while they're not your advocate, that's a check in many ways on the school's power and how they're handling a request for accommodations.
We have another question, Mary. So it says, what recourse does the student have if a professor or, unfortunately, the representative of disability services is unaware of the accommodations available to the student and they are penalized or outed to other students that they have a disability and they need additional time or simply discretion to complete their degree?
Okay, so the question was, I'm going to recite back part of it, is what do you do if you have accommodations that have been approved, but the professor is unaware of those accommodations and they haven't granted it to you, so you are unable to meet academic requirements and then you fail out or meet some other consequence? That's my understanding of the question. So under those circumstances, the school has an obligation to let the professors know what the accommodations are. Now, many times I've had schools say, well, it's up to the student to go to the professor and tell the professor, oh, well, I've been approved for, XYZ accommodations and I need them for this class. Schools try to say that, but under the law, they're the ones that are obligated to make sure that their professors, agents for their institutions, are following the law and accommodating individuals with the modifications that have been approved. So in that situation, that's discrimination, right? And then depending on your timing and depending on your means, you would file a complaint with the Department of Education, file a complaint with an administrative agency, retain an attorney to either appeal internally on your behalf. Very often I'm able to achieve the results that I do without ever litigating. It's very rare that we have to litigate. Usually communicating with the school by letter and telephone allows us to clarify their obligations, clarify the needs of our client, and we're able to resolve things. Oh, and lastly, litigation, which, as I said, is expensive and it can be time consuming and there are no guarantees, but it is still a potential way to get some sort of redress. But that would be discrimination, absolutely.
Mary, we have another question from Kathleen. Kathleen wants to know, can you explain what is considered a reasonable accommodation versus what the student prefers in relation to a human reader versus a screen reader?
Yes. So an accommodation is reasonable if it does not fundamentally alter the school or the testing company's program, right? And none of the accommodations that I listed would alter most things, because those, let's take a test, for example. The test isn't measuring your speed, it's measuring your reading. It's measuring your comprehension and your writing. So extended time, for example, does not create an unfair advantage. And it also doesn't burden the schools or the testing companies, because they have the resources to provide a proctor, or to allot additional time to administer this accommodation. Now, with regard to student preference is often misunderstood. So what's effective is what works for the student. Very often there are things that people have not tried, that it's not their preference. They haven't tried it, maybe it'll work better for them. But if they don't know how to utilize it properly, then it's not accommodating for them. With regard to the human reader versus the screen reader, in order to demonstrate whether one is more beneficial than the other, the student's doctor, etc., or et al., they would need to explain why that's the case. And I could go into a lot of detail about that, because I recently had a situation dealing with human reader versus a screen reader. But for many individuals, using a human reader is more cumbersome, because you have to work with them to like point out what you need them to reread, and you have to tell them, well, can you go back here, can you go back there? Whereas with the screen reader, you're able to point to it, and it might seem minor, but something like that can really interfere with concentration and fluency when completing an assessment.
Mary, Melanie definitely has some more questions that she would like to ask you privately, so I'm going to be connecting you with her offline. I wanted to thank you so much. Oh, yes. Sorry about that. I wanted to thank everyone so much. I do apologize about the slight lag with the video with Melanie's audio, with Mary's audio, but I have to thank you so much, Mary. Your presentation, your knowledge, your expertise, your view on things, and the way you can explain them to people, regardless of where they are and where they're at in terms of industry or career, is fantastic. And I just want to thank you so much on behalf of St. Joseph's College, on behalf of the Office of Alumni Engagement. We are truly honored to have you present with us today, and we hope that you will be doing future webinars with us.
Thank you for having me, and I look forward to that.
Thank you, Mary. Thank you, everyone, for joining us. We will be sending you the recorded version of this. We will be giving you access to that. It will be featured on our Alumni Video Vault. We will also be sending you a survey immediately following this webinar. So once the webinar is concluded, it will pop up right on your screen. You'll also receive it via email as well. We do appreciate your comments. We read every single comment, and we really try to make sure that we incorporate your feedback. So thank you again, Mary.
Thank you.
Thank you, everyone. Have a great afternoon.